And we're good to go.
Afternoon. I want to welcome everybody to the November 17th meeting of your Virginia State Board of Elections. We're going to make history today. This is the first time ever that we'll have campaign finance penalty appeals for us. So welcome to the meeting. Should we ask for approval of minutes? Should we take the roll? We'll take a roll.
Chairman O'Bannon.
Here.
Vice Chair Dance. Here. Dr. Stolley.
Here.
Mr. Peterson.
Here.
Secretary Albus Long here.
Great, thank you very much. I want to welcome our attorneys, Mr. Polio, Mr. Murphy. Appreciate the commission being here. Now we'll do the minutes.
Now you'll do this. Okay. Mr. Chairman, the September 17th, 2025 State Board of Elections meeting minutes have been distributed to the board for their review. If there are no corrections or additions, then I would request that you ask for a motion to approve them as distributed and presented.
Great, the motion.
Second.
Thank you.
Chairman O'Bannon.
Aye.
Vice Chair Dance. Aye. Dr. Stolley.
Aye.
Mr. Peterson.
Aye.
Secretary Albus Long. Aye.
Great, thank you. I will now undertake public comment. You know, the standard approach to this is we'll hear from folks that are physically in the room. And we'll hear from folks online who wish to make public comment. I'm going to respectfully ask that we hold it to 3 minutes each in the interest of the length of the agenda today. And if you are offering public comment virtually, we'll need to be able to both hear you and see you for that public comment to count and be entered into the record today. So anybody here in the room that would like to make a public comment? What do we have online?
No public comment online.
Just go ahead and mute it until they call for this.
All right, great. Commissioners report.
Chairman O'Bannon, Vice Chair Dance, and members of the board, I'd like to start by thanking all of our local election officials for a very smooth election this month. Virginia's general registrars, their staffs, electoral board members, and thousands of officers of election worked for months to ensure that every eligible voter had the opportunity to vote and that all of those votes were counted accurately. I'm very grateful to all of our state's election officials at every level for their commitment to their fellow Virginians. Now that each locality has completed their canvass, the Department of Elections will review the abstracts of votes for that third check of election results. As you know, we check election results 3 times in Virginia: at the precinct on election night, during the canvass, immediately following the election, and at the state level prior to certification. We will also conduct the statutorily required risk committee audit this week. Virginia is one of the few states in the nation that does their audits prior to certification. And today the board is going to choose which House of Delegates race will be audited. The board will also hear appeals of campaign finance penalties as required by code for the first time, as you said, Mr. Chairman. And then the board will meet again in 2 weeks on December 1st to certify the results of the November 2025 general election. And that completes my report. Thank you.
Thank you very much. And I just want to echo what you said. We really work our GRs and our EVs, the general registrars, elected boards, very hard in Virginia, and they really came through this time. And we had this wonderfully boring election. Not that I like the results, but we had a very safe and successful election here in Virginia. All right. Next item is 5, Mrs. Gaines. Welcome.
Hello, Chairman O'Bannon, Vice Chair Dance, Secretary Albus Long, and members of the board. You have a memo before you finalizing 2 decisions made from the September 17, 2025 Stand By Your Ad meeting. It was voted that the Friends of Shane Boswell Committee receive a $100 penalty, and dismissing the Friends of Joe Brand Committee complaint. A recommended motion is before you.
Thank you, sir. So as everybody knows, we listened to the stand by your ads. The process requires that we reapprove this at this meeting, so is there a motion?
Mr. Chair. I move that the board finalize the decisions made on the two stand by your ad violations assessed in the September 17, 2025 State Board of Elections meeting.
Second.
Motion is before us properly seconded. Is there any additional discussion? All in favor, let's call the roll, please.
Chairman O'Bannon.
Aye.
Vice Chair Dance.
Aye.
Dr. Stolly.
Aye.
Mr. Peterson.
Aye.
Secretary Elvis Long, aye.
All right. Item number 6.
Thank you.
Thank you, sir.
Good afternoon, Chairman O'Bannon, Vice Chair Dance, members of the State Board of Elections. Today, we will be performing certain administrative tasks related to the risk limit audit for the Virginia House of Delegates. First, we will be selecting a House of Delegates district race for that RLA, followed by generating the random seed number, and then by giving notice to the date and time of that RLA. As you know, pursuant to 24.2-671.2, the SBE draws the contested races that will conduct a risk limit audit and the method that will be utilized. As a reminder, during September's meeting, the board approved an RLA for the Virginia House of Delegates race utilizing the ballot point method. And with that, we will begin with our first administrative task, selecting a random House of Delegates district race. The SBE or their designated representative will randomly select a House of Delegates district race for the RLA this year. A list of eligible House of Delegates district races is included in your memorandum and is also displayed on this table before you. Elect will place the numbered discs into the tumbler. Each disc represents a different House of Delegates district race that is eligible. The chair of the SBE will mix the tumbler. The vice chair of the SBE will then select a single numbered disc from the tumbler and state that number on the disc. And with that, there is a proposed motion in your memo.
All right, a motion.
Mr. Chairman, I move that the State Board of Elections randomly select House of Delegates district for the RLA, also described in the memo presented.
Is there a second?
Second.
All in discussion, call roll, please.
O'Bannon.
Aye.
Vice Chair Dance.
Aye.
Dr. Stolly.
Aye.
Mr. Peterson.
Aye.
Secretary Elvis Long, aye.
All right.
Dr. O'Bannon, Vice Chair Dance.
Oh, okay, that's easier.
What happens to these tokens?
We,
Use them again?
yeah, we have a storage.
Might be suited to use.
You would, those are the ineligible. Give the tumbler a quick spin.
Just gonna brace the tumbler, just so.
We call you Lady Luck.
Is that what you saw? I don't know. All right,
And if you would turn your head.
I'm watching that gentleman right there. Is that a good thing for you? All right.
Very
So
good.
there, am I in? Okay. Whatever I get, it's on you. 92.
92.
Thank you all.
Yes, sir.
Those are that.
Good afternoon, Chair O'Bannon, Vice Chair Dance, members of the board. generating a random seed number for the randomly selected House of Delegates district race. The RLA software that we will use for the RLA uses a 20-digit random seed number to generate a random sequence of ballots to be selected for retrieval. This seed number is created by rolling 20 10-sided die each once and recording each number. The 20-digit number generated by this activity will be inputted into the RLA software by the RLA administrator and used for the selected race. Once this number is inputted, the auditing software will randomly select and generate a list of ballots to be retrieved based on the sample size. Elect staff recommends having staff members roll 20 10-sided die once each to generate the random seed number. A suggested motion for board members is included in your board papers.
Motion.
Mr. Chairman, I move the State Board of Elections direct elect staff to generate the random seat numbers for the randomly selected House of Delegates district race.
Second.
So this is detail of how the process works. We get down to do the audit. And this is prescribed.
Yes.
All right. Any discussion? Call roll. Motion.
Chairman O'Bannon.
Aye.
Vice Chair Dance.
Aye.
Dr. Stalling.
Aye.
Mr. Peterson.
Aye.
Secretary Elvis Long. Aye.
Roll the dice.
5, 9, 8, 9, 8, 2, 9, 6, 4, 9, 9, 2, 3, 0, 7, 6, 8, 0, 3, 1.
I will read back all 20 numbers in sequence. The first number is 5,
5,
9,
9,
8,
8,
9,
9,
8,
8,
2,
2,
9,
9,
6,
6,
4,
4,
9,
9,
9,
9,
2,
2,
3,
3,
0,
0,
7,
7,
6,
6,
8,
8,
0,
0,
3,
3,
1.
1. Now we come to the last item. Date and time of the RLA. pursuant to 24.2, 671.2G, elected to provide notice of the date and time, location of the RLA. The Virginia House of Delegates district that was pulled was 92 and will begin on Thursday, November the 20th at 10 a.m. The RLA will be held at public meetings within those localities selected to participate. Please contact your local general registrar's office for more details as to the location of the RLA on November 20th, starting at 10 a.m. Thank you very much.
All right. Discussion of the.
Sorry.
Okay. Item 7, campaign finance penalties appeal period.
Good afternoon, Mr. Chair, Madam Vice Chair, members of the board. As Chairman O'Bannon stated, this is the inaugural effort here at reviewing campaign finance penalty appeals. Just for some background on this, the ability to appeal campaign finance penalties came from legislation passed in the last legislative session. The board has discretion if good cause is found, in your opinion, if there's good cause, if an appeal has been made alleging either that there were circumstances present that made filing on time or requesting an extension before the deadline impracticable, or if there was an administrative error that occurred in the assessment of the penalty. So as you'll recall, previously, you all approved the campaign finance penalty appeal procedures policy, and that's been included in your packet. That established procedures for this hearing in order to hear these appeals. Consistent with the policy, ELECT received all of the petitions for appeals, created the process in which people could submit their petitions, and then scheduled 15 appeals and prepared all of the materials that are in your packet today. You'll notice that the appeals are in 2 different packets. There are the state issued penalties and then the locality issued penalties. Under the statute, all of these appeals are heard by the board, no matter who it's issued by. So for this process, consistent with the policy that you approved, the petitioners were all notified of the hearing date once we reviewed their petition to make sure all of the necessary information was provided. And they were provided the option to attend in person or remotely. So we have a mix of that. For local penalties, the registrars were notified once we received an appeal, and they were requested to provide both a response to us and then also to be available to attend today so that you could ask questions if you have them. ELECT will present each appeal to the board one by one. And after we present, Emily Minarski from the campaign finance team will be the one to present each appeal. After she is done, the petitioner will have an opportunity to provide oral testimony and submit additional evidence if they have any. And then at that point, the board will have the opportunity to ask questions of the petitioner or of ELECT, or in the case of a local penalty, of the general registrar. In terms of a decision, you will make your decision today after each one. There's suggested motion language in the memo included in your packet. And then within 21 days, a written opinion of your decision has to be issued. So we will take all of the decisions that you made today. We will put them into a proposed draft written opinion that will be distributed to all of you for your review. And then once those are approved, we will send them to the petitioners and also post them on the website. So when you're making your decision, we just have the recommendation that you kind of review each one and simply ask yourselves if the grounds that each petitioner provided constitute good cause to justify relief. Again, that's your judgment as to whether good cause is there. And then if so there is requested relief that each petitioner asked for. So if you think there's good cause, you can either give relief as requested by the petitioner, or you can come up with whatever relief you think is necessary or is proper given the circumstances that are provided. So with that, before I turn it over to Emily, if any of you have questions regarding the general process, I'm happy to answer those. Otherwise, she can get started.
I just want to remind everybody that this is the direct result of a bill that passed 2025 General Assembly of Virginia. So if if you have heartburn about some of this, talk to your members of the General Assembly, because they directed this whole process, and we're now way down the road in this process because we've had these respective penalties issued. We've had folks the opportunity to respond, and a lot of interaction between. You'll see that a lot of research done. And so it's now our job to go ahead and adjudicate these based on the responsibilities that we were given in this process. So don't shoot the messenger. Also respectfully ask that keep that 3-minute rule if possible regarding testimony on all sides. I'm not going to try, nobody's going to get cut off, but we be respectful of everybody's time. We're going to do the
We have,
first.
we have some housekeeping for that.
Yes, ma'am.
So prior to proceeding with the hearing, elect has received 2 requests for continuance for scheduled appeals hearings. William Lyons II has requested a continuance. His hearing was scheduled for today, November 17th. And Thomas Burns, his hearing was scheduled for December 1st. He's also requested a continuance. Both continuance requests were submitted to elect within the 7-day deadline. Per the board's policy, and both continuance reasons were related to the petitioner's counsel not being able to attend at the scheduled hearing dates. Requests for continuance must be approved by the chairman per policy prior to rescheduling a hearing. So, Mr. Chairman, do we have approval for both continuance requests and permission to proceed with scheduling?
You just told me I must do it.
Well.
Let me ask a question. I didn't realize we had more of these on the December meeting.
Yes, we do. Right now, I believe we have 10, although one is pending continuance request. So we do have some possible dates for these individuals. So it's just up to you.
Is this going to require another meeting, or will this be part of our regular meeting process?
I imagine it's going to be a part of the meeting process going forward as we get the hearings, unless,
So the absent concern or objection, the continuous request will be obviously granted.
Okay, awesome. We do have some future dates that we could do some these people. So, all right, thank you. We'll notify the individuals. So all petitioners were notified of the hearing date and are provided with the option to provide oral testimony, either by themselves or counsel. For both state and locally assessed penalties, elect staff are present to answer questions, and for locally assessed penalties, the general register was requested to attend the board, should the board have any questions. For the sake of time, all provided petitioner grounds were summarized by elect, and the full petitioner statements are included in the petitions, which were provided previously in the board's papers. So, Mr. Chairman, with permission, we will proceed with starting our first petition, which will be for state assessed penalty.
Go right ahead.
So we will now start with the state assessed penalties. And elect is available for questions for these petitions. So we will start with friends of Philip Scott, the petitioner, Philip Scott. He was assessed a $1,000 penalty for a report deadline back in July 15th. So on July 15th, Mr. Scott experienced a technical difficulty while traveling that led to filing the report late on July 16th, 2025. He is appealing for the basis that circumstances made filing the required report or requesting an extension by the deadline if practical, and he is requesting full relief. So that concludes my brief of the petition. With permission, we may hear from the petitioner if he is available.
All right.
Yes, I'm here. Good afternoon. As I said in the request, I had a flight out of Richmond at 8:15 p.m. on the 15th. Supposed to get into Dulles or DC at 10:15. In Richmond, that flight was delayed. Time my flight got to DC, I had to turn around and get back. I'm sorry, it's supposed to get in at 9:15, giving me an hour. But by the time the delay happened, I had just enough time to get from one gate to the next. Didn't have time to try and connect in DC to get on before I got on my flight to Indianapolis that got in at midnight, a local time there, which was past the time here to get in the report on time. Ever since then, I have been very diligent to make sure that when I hang up something planned, I have the ability to get that, and I've done that. And so I'm just asking for this opportunity to ask for forgiveness on this and to have the penalty dismissed.
Thank you very much. Yes, ma'am.
Mr. Scott, I'm listening to your whole explanation for why this situation happened. And one thing you just said is that you've been diligent, and then like this is maybe your first, but the information I have in front of me says that in 23 and again in 24, you were like pushing the wire. So that seems to be a pattern. This is just my looking at it versus where you haven't allowed yourself time to do this in a timely fashion.
Would you like to respond?
What, was there a question in that?
Yes, it was, I guess maybe I didn't describe it. I'm not a lawyer, I'm just a layperson, but what I see here is a pattern. When you made the statement as though this was like a first time thing that you've been diligently complying, and I'm looking at information in front of me as far as reported deadlines and how you were like at the wire on, should I give you this information because you're riding? So I can just tell you briefly what I have in front of me.
I'm not driving. I'm not in the vehicle. I'm in Georgia, headed to family vacation in Florida. But I didn't want to ask for continuance. I don't want to waste y'all's time. Yes, ma'am, you are correct. There have been a couple other times where I have missed that filing deadline and did that. And yes, I know this is like the third time I think that I have missed that filing deadline. Other times it was just due to, hey, I didn't hit the submit button on time. This time it was not due to any negligence on my part. I had the information with me. I had my computer with me to file that. I got to the airport early. I was unable to connect to the internet. I tried using my hotspot. My computer wasn't connecting with the airport Wi-Fi. The flight was delayed. So even that hour between landing in DC and then flying out to Indianapolis, that was gone because of delay. I had every intention of doing that. I have learned from those previous ones, but the circumstances surrounding this was I was traveling, I was having internet issues, and the flight was delayed that prevented me from trying to connect in DC once the flight from Richmond to DC landed. That's the circumstances surrounding this. If it had just been like the other ones where I just failed to submit it, then I would not be asking for this exemption and for the dismissal of the penalty. I hope I made that clear. If you have any further questions, I'll
I don't have any more questions.
Secretary Albus Long.
I guess this question is actually to elect. I'd like to find out, is it absolutely that the 15th is the only day they can file, or do they have days before that they could have done this before someone got on a plane?
So for this particular deadline, the reporting period allowed them to file from July 1st through the 15th.
So anytime from the 1st to the 15th, it could have been filed. It did not have to wait until, I'll say, the last minute.
Yes. So for this this particular one, yes, it was 15 days filed.
Anybody else have questions? So may I ask you a question? Mr. Scott,
Yes, sir.
did you pay the $100 for 23 and $100 for 24?
I believe I did. Yes, sir.
Anybody have any questions? No. Discussion, we will need a motion Is there a suggested motion?
Yes, there were suggested motions within your packet. The suggested motion was either to, either grant the relief as requested or partial, or dismissing the appeal. Options, but the exact words, were within the memorandum in your working papers.
All right, any discussion?
Mr. Chair, based on the information presented, Rationale for it, I move that the State Board of Elections dismiss the petitioner's appeal of the assessed campaign finance penalties for failure to show good enough cause. If this had been a first time event, I think that would be a little bit more lenient than being a third time and at the last minute.
So your motion is to dismiss the appeal, which would uphold the penalty.
Yes.
Does that have a second?
Second.
Been second, properly seconded. Now it's open for discussion from the board. Anybody have any further? Absent comment, let's take the roll.
Chairman O'Bannon,
Aye.
Vice Chair Dance,
Aye.
Dr. Stolly,
Aye.
Peterson, Secretary Alice Long, aye.
Thank you very much, Mr. Scott.
Thank you all. You have a good day.
Let's go next one. Alright, so this one's also state assessed. So right now we have Alexi, sorry, if I mispronounced that, for Virginia House of Delegates. Petitioner Sylvia Alexi, is appealing for a $100 penalty. This was issued for the missing of June 9th deadline. She is stating that the circumstances made filing the required report or requesting extension by the deadline was practical, and she is requesting full relief. She is stating that she is a full-time candidate with time restrictions, and she was not able to fully understand the reporting requirements, and the $100 penalty may pose to be financial burden on her. So yeah, she is requesting full relief, and that concludes my portion of the brief. If you have any questions for me, answer any. Otherwise, I think we can maybe see if she's available.
Mr. Chair,
Senator Peterson.
I think staff said she was a full-time candidate. I think she meant to say full-time mom.
Oh, I'm sorry.
Like you said.
Yeah, sorry. I think I said first time candidate. I meant first time candidate. I'm sorry. Yes. I think maybe I confused full relief with first time. Yeah.
Got it. Okay.
Yeah, I'm not sure. Oh, she is.
All right, welcome. You're welcome to speak.
Oh, hi. So I'm actually seeking either a full or partial relief, and I am a full-time mom. And it was my first time running, and I have never been involved in a campaign. I'm not an attorney. It was my first time working with elect, and I should have read it more closely, but the summer started, and my children were home. And it was hard for me to find the time to fully understand what I was required to do. And it's my fault. I should have read it better. I accept responsibility, but if possible, since it's my first time and I have kept all my other requirements, I will ask for this relief.
Great, thank you very much.
Can I ask staff if this is what we have? There are no other.
I'm sorry, did you have a question?
She said she met all other requirements.
Right.
All of the requirements. I'm not aware as far as any like candidate qualification issues, but I mean, as far as
I'm sorry, reporting requirements. I have not gotten another fee.
as far as I'm concerned, she hasn't filed anything else late. She just filed this one. This one more report.
Anybody else have any questions?
Just clarification.
Sure.
So just so that I'm following, she submitted her paperwork on June 2nd, and that triggered a report by June 9th. So she only had 7 days to figure this out.
So it starts the clock. So as soon as you have activity, like filing your qualification paperwork, it starts the clock on activity. So the reporting activity for this one, because you have to file for reported activity through, I believe it was June 5th. If you have anything before June 5th, you have to file it on the June 9th deadline.
So she submitted on June, Mr. Chairman.
Right.
She submitted on June 2nd.
Yes.
June 9th report was done for the activity between June 3rd and June 5th.
Or June 2nd, June 2nd,
Second.
June 5th. Yes.
Thank you, Mr. Chairman.
Recommendation?
Suggested motions were the same one as prior, to either provide full relief, partial, or dismiss.
All right.
Mr. Chairman.
Yes, sir.
Pursuant to section 24.29, 53.6 of the Code of Virginia, because petitioner has demonstrated good cause to justify relief of the assessed campaign finance penalty, I move the state board of elections grant relief.
Second.
Thank you.
There's a motion properly seconded to grant full relief for this appeal. Question? Any discussion? Call the roll.
Chairman O'Bannon.
Aye.
Vice Chair Dance. Aye. Dr. Shelly.
Aye.
Mr. Peterson.
Aye.
Secretary Ellis. Aye. And move on to the next one.
So our next petitioner, Keisha Preston for delegate. So she has been experiencing health issues, and this has led to an inability to file a report timely. She has also submitted additional paperwork today. So that was added to the packet. But just kind of going over the report that is being appealed is the September 15th, 2025 deadline. She had circumstances that made filing required report or requesting extension by the deadline impractical, and she's requesting full relief of a $100 penalty or $1,000 penalty. Sorry. Is there any questions for that?
Is there any question?
Mr. Chair. From my,
I mean, this year.
Madam Chair. Why is one 100 and one's 1,000? Is that discretionary?
No, so the first one is $100. That's the first offense.
Got it.
Within the election cycle. The second offense within the election cycle is 1,000. For this one, it's 2-year cycle.
First is 100, second is 1,000.
Yes, yes. And 100 is set by the state board, 1,000 is set by the code itself.
And I
Any
am
other questions?
present. I just wasn't able to unmute.
You don't have any more questions?
Any other questions? You have a question? You have a question?
Are you all able to hear me?
Yes.
Yes.
Yes,
Okay, perfect. Sorry, I was having a hard time getting unmuted. So
bear with us for just one moment, Keisha.
yes.
Thank you.
Again, I guess my question is there a time frame that this could have been?
Sorry, perfectly, like, you mean like this time frame in which they sort of
Filed
Filed.
beforehand.
Oh, yes, this is the September 15th deadline, so that is gonna be a period as well as 15 days as well. So from September 1st through September 15th. Yes.
Question.
Another question?
Yeah, I would just like to ask Ms. Preston, the 15 days were, I mean, not to get in your personal business, I'm a nurse myself, so I know confidentiality of patient rights. Is there any time during that 15 days that you could have taken care of this?
I mean, technically, yes. I don't know if you all kind of want me to launch into kind of what I was going to say or if we're still asking questions, but I'm happy to explain further if you guys would like me to.
She has submitted in writing her rationale for her lateness in responding. So are there any other questions? Want to have her make them back to you?
Well, I was just going to suggest, having oral testimony if she wants to provide.
Sure, I can do that.
Sit down.
You may begin.
Thank you. So I first want to start by saying thank you all for allowing me to speak today, and thank you for your time. I also want to acknowledge that I do have a little bit of anxiety speaking with you all today because I am going to be talking about my mental health, and there's still a lot of stigma about that. But I think it's important, A, to advocate for myself, and B, because I think the more that we talk about this stuff in the open, the more we kind of remove the stigma that exists around it. So that being said,
Can I help you with just with this information? That there are 5 of us here that serve on this board. Two of them are physicians, 2 are nurses. So I think we might understand where you're
gotcha.
Right?
Thank you for that.
Just tell us what you'd like to tell us. Right?
Yeah, so in 2017, I was diagnosed with post-traumatic stress disorder. And it is something that's been fairly well controlled for the last few years. But unfortunately, this year, I kind of experienced a series of events that I would call a perfect storm that kind of launched me back into crisis. And as I'm sure most of you guys are aware, a lot of times when someone is experiencing a mental health crisis, they're not immediately aware that that's what they're experiencing. And so immediately after my primary, I would say that's really kind of when it began. And unfortunately, I was just in a space where I was really kind of unable to function. And the end result was 2 of my reports not getting submitted on time. Once I realized what was going on with me, I did take the steps that I needed to take. I reached out and got back into therapy. I reached out to my primary care physician and resumed taking medication. I'm feeling significantly better now, not back at 100%. But I also do want to acknowledge that every campaign finance report that has been due since I took the steps to get the help that I needed has been submitted on time. I want to take full responsibility for this. You know, I fully acknowledge and understand how important it is to get these submitted in a timely manner. And I take full accountability for the fact that they weren't submitted on time. But I am asking for grace just based on A, the extenuating circumstances behind it, and B, the effort that I've shown to take the steps I need to take to, number 1, make sure that I'm okay, but number 2, to make sure that this is not something that continues to happen moving forward.
You all have any, now that she's made her, she's given us her explanation in writing, and now she's given us her verbal explanation. So now, members of the board, are there any questions you have?
Sure. Question. I'm just looking at other penalties that have been assessed for previous times being late. Looks like this is actually the 6th time that the penalties been late. Has it been the same circumstances for each of these, or is this time unique?
This time is unique. I'm actually not entirely certain where 6 came from. Is that from this particular election, or is that from previous elections as well?
Previous elections as well.
Gotcha, yes. So yes, this has happened before in the past. However, this is unique. This was not the cause for the previous late filings.
Any other?
I apologize.
Sorry.
Apologize for getting out of the room, but I do have a question.
Yes.
Did you pay all these other penalties from 20 through 25?
I actually don't recall receiving any information about penalties from those dates. I know that they were late, but I don't recall receiving any documentation from it. I did pay the $100 penalty that I was assessed for the fee that came prior to this. But if there are any penalties that came prior to that, I'm not aware of them.
And I have a question for Lex. Do we have any way to validate whether these penalties were paid or not?
The previous ones, those would have been paid local, because I believe that that was from a local election, or sorry, local assessed penalties. So that would have been, I believe that was from the city, I believe. So that would have been paid through.
And if a candidate has a an issue, a health issue, and they choose to draw or stop their candidacy, does that get them off the hook on these filing obligations?
So filing obligations continue until you file a final report. So you have to file reports until you close out the bank account and submitted your final report.
Okay.
You have questions? No other questions? Then board members,
Recommendation.
what do you think?
Recommendations,
Right.
grant, full relief, partial, or dismiss.
Okay, board members, what is your pleasure? Is there a motion? Is there a motion? There seems to be a sense of unreadiness. I'll ask our legal advisors, if we cannot make a motion on this, what are the remedies?
Madam Vice Chair, I believe you can take one of the recommendations forward. You can continue, you can make a motion that you will continue to deliberate on that.
All right, members of, do I have, if you all cannot.
I'll make a motion.
Okay, what is your
I
motion?
make a motion to reduce the penalty to $500.
Is there a second?
Second.
It's been moved and properly second, Secretary Polly.
Chairman Bennett,
All right.
Vice Chair Dance.
Aye.
Dr. Stoney,
Aye.
Mr. Peterson.
Aye.
Secretary Ellis Long, aye.
Motion passed. Back to you, Chair.
Thank you very much. I apologize for that. Next.
Thank you.
So you're still on state assessed. We're moving on to Forensic Pam Garner. Petitioner, Pamela Garner. She had a report that was due on July 15th, and she was assessed a $100 penalty. She stated that there were circumstances that made filing the required report or requesting an extension by the deadline practical, and that there was an administrative error in the assessment of the penalty. She stated that she experienced technical difficulty and was not able to complete the report until July 22nd. And so elect has addressed the alleged technical difficulty in the board papers. She is, I believe, requesting full forgiveness of the penalty and retroactive extension. I'm not sure if she is attending with us.
Not have Pamela.
She didn't confirm with me if she was going to attend or not.
Mr. Chairman, can I just ask clarifying?
Delegate style.
So she went to file her report, but instead of filing for the current report, she ended up doing an amendment to a previous report.
Yes. I'm sorry, what's the question?
That was my question. Is that correct? Just on.
Okay. You're just asking if that's what happened. I believe that is what was being stated within the brief, is that she filed a report, and then she ended up filing an amendment for the previous report instead of the required report for that deadline.
So, Mr. Chairman.
Yes, I'm ready.
The intent was that she was to file on time. However, she made an error in the filing.
She made an error in the filing in that she filed an amendment to a previous report.
So just so I understand, this was not any kind of technical error on the part of the elect.
No, reports are manually prepared by the user. So they go through and they choose the report and file and prepare it.
So it was her technical error.
It would have to be with the user, yes.
Got to be clear.
Yes, the user prepares the report.
And she has not had any others. Based on the records. Given.
No, I have not seen any prior links.
Chair.
Vice Chair.
It's appropriate or not, I move that we dismiss the petition appeal that she attempted. She did a lot of wrong things, trying to do something right, and ultimately it was wrong. She's not here to defend herself, but I think we should, dismiss that. That's what I recommend.
We're granting her appeal then?
I move that we dismiss the petitioner's appeal, the assess campaign, is that the right one?
So dismiss means that you're dismissing the petition, and you're not granting relief.
Sustain the fine.
Well, actually, we are granting her appeal, she's asking that we move this, I move that we.
Okay.
Grant her appeal. Thank you.
Is there a second? Second. Any discussion on the motion? Call roll.
Chairman O'Bannon,
Aye.
Vice Chair Dance,
Aye.
Dr. Scully,
Aye.
Mr. Peterson,
Aye.
Secretary Elvis Long, aye.
All right.
So this is for Virginia Hospital and Healthcare Association PAC, petitioner is Julie Dime. She had a report that was due on not July 15th, September 15th, 2025, and she submitted it the next day. They were assessed a $100 penalty. So they stated that the circumstances made filing the required report or requesting an extension by the deadline practical. The committee stated that they experienced technical difficulties while attempting to file the September 15th, 2025 report. Elect has addressed the alleged technical difficulty in the board papers. The committee is requesting full relief for the $100 penalty. I am not certain if Virginia Hospital has they would like to.
All right, well, we've heard the penalty work done on this particular penalty. Is anybody from the Hospital Association present?
I don't have anyone from.
I do have one question. Hanging out on the next page, there's a $1,000 penalty from October. Can you tell me about that?
Yes, so that one I believe was from, it's like a large contribution report. That one was not filed timely.
But that one is not before us,
No, that one has not been appealed to my knowledge.
will be.
I do not know. Not yet. I have not received a petition from them.
All right.
I am online. Hi, I'm Jerry Gray Benedy. I'm with Public Affairs Support Services. We do the filings for Virginia Hospital and Healthcare Association PAC.
Go right ahead.
Yes, so on the 15th, we had some technical difficulties and were unable to file the report, but it was filed at 8 a.m. the next morning. We're asking for relief on the $100 fine. The one that was in October that recently happened, that was a credit card that came in late in the afternoon and it was a Friday and did not get filed by the deadline of Saturday, which offices aren't open on Saturday. But that was paid in full to Virginia Elections.
So, may I ask?
But prior to that, we had not had any, I went through Comet and looked, all our scheduled reports have been timely since 2012.
So that was my question. You all are a vendor or third party that helps the Hospital Association file their reports?
Yes.
And I think you just addressed this, but you said you have not had any examples or citations other than this one?
Yes, sir. We had no, on the timely scheduled reports, we have not had any prior times where we were filing late.
Okay, anybody have any other questions?
No, we don't have any questions. We have, sense of unreadiness.
Delegate Stoller?
Yes, Chairman. I'm going to abstain.
And
So-
I have to abstain.
Wait a minute now.
We're clear understanding.
So what we have here is the unique circumstance of an entity that contributes money to campaigns. And so I guess they've contributed to me, but it's been several years. Do we have any guidance on whether we should, what are the parameters upon which we would need to abstain? And I will just say that this may be a place where a continuation to check into this might be an appropriate option. Y'all want to opine on this right now?
Mr. Chair,
Yes, sir.
and I have the same, I received a donation, I also long time ago, my opponent received a donation. I would simply say that disclosure, of course, is the best disinfectant. You can look this up on BPAP that myself, and I'm sure other members that have been members of the General Assembly received a donation from the.
I have received a donation. I actually thought. I have received.
Yes, no, yeah, that's what I'm saying. The fact that you receive a donation, of course, would not disqualify you from voting on the matter in the General Assembly. I don't think it'd be a legal, prevention for voting matter here. Of course, you can.
Consult.
It's one person at a time.
Yeah, you can.
Chat.
You can you can recuse yourself if you want. I'm gonna have a similar issue on the next, candidate. Yeah, so that's what, I don't think there's a legal disqualification. It's just a matter of if you want to vote on it.
Hey, anybody else have any comments?
Mr. Chairman, I would make a recommendation that we continue this until we've had an opportunity to discuss this.
Okay, that's a motion. Is it?
And I'm second.
It's motion properly seconded that this be continued to a later date. We can discuss it. I will say this, I think at some point, after a number of years, that issue of a donation becomes less significant, if not moot. But that's just my 2 cents worth. So there's a motion before us. Unless there's further discussion, let's call the roll.
Chairman O'Bannon.
Aye.
Vice Chair Dance.
Aye.
Dr. Stolly.
Aye.
Mr. Peterson.
Aye.
Secretary Alice Long.
Okay, so that can is kicked down the road. Next.
So the next appeal is for Virginia Restaurant Lodging and Travel Association. There were 3 different reports that were failure to file, in total $2,100 for assessment penalties. They're stating that circumstances made filing their report or requesting an extension by the deadline impractical. This petitioner was Mark Herbert, I believe he is here today. So they're stating that due to issues with bookkeeping, that and not having knowledge on these specific reporting requirements, the committee mistakenly failed to file 3 large contribution reports. Electives provided documentation related to these penalties in the board papers. They are requesting full relief.
All right. Let's hear from Mr. Herbert.
Good morning, Mr. Chairman, members of the committee. Mortified to be standing in front of you today. As is laid out in the packet, there is a material circumstance that prevented me from being able to file these large contribution reports in a timely manner, which is that our organization contracts out our bookkeeping, and therefore our bookkeeper is only paid to handle our PAC donations once a week. The underlying cause, however, is my misunderstanding of the new lower thresholds for large contribution reports during the specific time period before the primaries.
All right, any further comments?
Mr. Chair,
Senator Peterson.
I think this might be the time for me to disclose the fact I was their legislator of the year in 2021, so. But you not cast a vote and have to give back that trophy, but,
Gotta be careful. We might ask you how much the trophy was worth.
appreciate it very much.
I would want to check too. I'm sure that I probably have donation, I don't know, if you're gonna deal with, donated.
So you,
Well, my son was in the restaurant business, that kind of stuff, I don't know. So nice, I like him.
you didn't make a motion. did you?
I was recusing myself on this.
I want to move to defer it so we can get better guidance on it before. My sense of unreadiness is I'd rather stand back versus vote on something I'm not sure.
So,
So I move.
what? That's fine. Let me ask one. What have you all done to rectify this problem?
We have changed our recording practices now so that we will never miss those specific date ranges that are required for the lower threshold.
We have a motion. Does anybody second the motion?
I didn't make it. I stopped before making a motion
Because I stopped. Thank you, motion.
I'm being respectful to the
Yes,
chair.
Go right ahead. Thank you.
I move that we table this one to get further guidance as far as what we can and cannot.
There's a second. Okay, motion properly seconded, any discussion, please call.
I think one postpone it. That's correct. You don't want to
I
table
will
it.
use,
Table
okay,
it. We're gonna do it
the
later.
motion directed to postpone this until we receive guidance from.
Motion properly amended at the request of parliamentarians.
Yes, thank you very much.
Any further discussion? Call the roll.
Chairman O'Bannon.
Aye.
Vice Chair Dance.
Aye.
Dr. Stolly.
Aye.
Mr. Peterson.
Aye.
Secretary Thomas. Aye.
And I do want to ask that when we do our closed session paperwork, that we include this specific, this is novel. It's the first time it's come up, so I think it's worth taking time to look at properly.
It's not the first time doing
Do
it.
that. All right, thank you, everybody, for that. Next.
Next, we have Peanut City PAC. This is for petitioner Matthew Kinson. Sorry, I mispronounced the name. They were assessed a $100 penalty for the October report of 2025. They're stating that circumstances made filing the required report of requesting extension of deadline practical, and they're requesting relief. The committee erroneously wrote the wrong due date when the deadline was. So they wrote down that it was on the 16th when it was on the 15th. Elect has provided documentation for this penalty, and I am unsure if Mr. Pitland is going to be joining us or not. I don't.
I'm here.
Oh, you're here.
Yes, ma'am.
Welcome. Please go ahead and speak.
Thank you. Yes, I unfortunately, when entering the data, and I can be technically challenged, I somehow entered the 16th as opposed to the 15th in my calendar. And when checking, I've never been late before. And I'm embarrassed at making such a simple, stupid human error. And, it's kind of like, I promise never to ever do it again. But I'm asking for your forgiveness on this one particular time that I just, human error, human defect error. I just entered the wrong date. And it wasn't until I realized when I get the notice in the mail that, I was late. So I responded immediately. I have been timely in all other prior filings. And so I'm asking for forgiveness. And all I can say is I thank you for your time and for hearing me out for such an embarrassing and stupid mistake.
Thank you very much. Do any members have any questions? So just for the record, you've had no prior penalties,
No, sir.
and I can't help but ask, can you tell me 30 or 60 seconds about Peanut City?
Peanut City, well, we're here in Suffolk, and, we support those who are running for this area that basically promote the agricultural industry of peanuts. I mean, this is the peanut capital. And,
Gotcha. Thank you.
okay.
All right, usual recommendations.
Yes, the motions, in your board papers, it was, pursuant to section 24.2-953.6 Virginia Code. That either they demonstrate the cause, grant full relief, or pursuant to same code, that you move to dismiss the petitioner's, appeal.
Is there a motion?
Mr. Chair, I move that we grant the appeal request.
Is there a second?
Second.
Motion properly seconded before us to grant the appeal request. Is there further discussion? Please call the roll.
Chairman O'Bannon.
Aye.
Vice Chair Dance.
Aye.
Dr. Stolly.
Aye.
Mr. Peterson.
Aye.
Secretary Elvis Long.
Thank you very much.
Thank you.
Now we're moving on to look at penalties. Elect is also available for questions, for these petitions. Please consider that, the general register is also available for questions for these petitions. Considering for the ones who assess the penalties. So we're going to start with Friends of Matthew Cross School Board 3/2021. Petitioner Matthew Cross. He was assessed about $9,200 in penalties for reports from December 2021 through July 2025. He is the basis that he's claimed that there was an administrative error in the assessment of the penalty. And he has stated that there were several administrative errors, that there were technical issues with email notifications, that there were no prior communications with the general register related to the penalties, and that the penalties may be barred from the statute of limitations, and the remaining penalties would not have occurred in this. The general register and elect have both provided documentation and informed. These, Matthew Cross as counsel that is
Let me, what's your account? Go right ahead. Come on up.
Good afternoon. Thank you for being here. It's pretty interesting to be the first time advocating for a statute that just got passed. But so far, I mean, you all look like naturals handling it, so thank you for that. It sounds like you may have already made yourself familiar with the material, but just to be short, Mr. Cross, who cannot be here right now, he may or may not be on the turning in. He's actually on a mission down at El Salvador and may have satellite connection, but I'll be one of. Anyways, to sum up, Mr. Cross was running for the school board up and running for the first time several years ago, back in 2021. That's when he established his campaign. And at that point, that's where and then he collected all the money initially. They ran the election, got elected, did not solicit or issue any more payments after that point. But then what happened was that they never got any further notices about, they didn't know that they needed to make any updates at that point, to be honest, for these periodic ones. And they were never asked to make any updates by the local registrar's office. And so they were along, comes time for this next round of elections. They go on to make sure all their financial documents and all the rest of that are up to date and freshen up the registrar's office. And they get notices that there are some late filings. He goes to fix that. He fixes all these things, makes sure everything gets brought up to date, tries to just make sure the filings are safe. The next day, he gets notified by the registrar that they're fining him for $9,200 for late filings, going back several years. As I summarize it here, my understanding is that he then went to the registrar's office, and now this is hearsay of hearsay at this point for me, so take that with a grain of salt. But he went to the registrar's office, and it seemed that she was under some type of impression that she basically had to issue these fines, and that she didn't have any discretion to address any of the tardiness or any of the other arguments, and that we had to pretty much bring it up. I'm not saying whether that's right or wrong, but that's one of the reasons why we're here. So if you look at these fines, we have several years worth of them. The statute of limitations is pretty clear that it's 1 year from date of discovery if you have some type of hidden issue, and then but no greater than 3 years period from the date of the violation. Because the nature of these are that they're late or missing, I would say that you would know immediately whether they're late or missing. It wouldn't be when you filed the update, it would be that these were due on a certain date. There was no report there. That's when it was due. So the bulk of these, $5,200 of those fines are well outside the statute of limitations at that point. And then, as I point out for the remaining violations, the thing is that we had a few of these violations where the deadlines passed this year or within the last year. And like I said, as soon as he realized that there was an issue, Mr. Frost immediately went and fixed it, and he opened up to make sure that he was up to date. And I know that if he had been told within if the registrar had brought it to his attention, either through a letter or something like that, or sometimes it has no interactions, he would have practically because of the subsequent fines. So Mr. Frost is very apologetic. I've had some conversations with him about this. He really does believe in transparency. He really appreciates what the registrar, what these laws are here for. It was, I believe, a very honest mistake, and he and his wife put some measures in place to make sure that these things don't happen again, which was about a long time.
And your name, sir?
My name is Tolly Gwynn, Tolley. My middle name. Gwin.
Thanks.
Here, it's down.
Oh, I should read it. Thanks. All right, any members have any questions?
Mr. Chairman, yeah. So I'm just looking at past here, and it looks like you filed 4 times too late. Well, Mr. Frost filed 4 times late, and then just stopped filing. So you had to know it wasn't just a one-time deal, right?
So my understanding for those was that they had some technical issues.
I'm not debating whether they're late. I'm just saying that he was filing and he knew that he had to file. And then he
Yes.
just stopped filing.
Yes, I believe that what's happening is that for some reason that he was not getting the common updates anymore at that point. So he was getting some of these notices to go and update his information. That was my understanding of there are some technical breakdowns. One of the issues was that it appears that his email, so they had like for their IT at his job, or he's a pastor at a church, and so he uses his work email for these things. It appears that it was no longer forwarding emails. Like at some point there was a domain issue, and so he wasn't getting common issues or common updates at that point. But as I understand it, some of these.
Right. So having filed a number of these, we didn't rely on notice that we had to do it. I mean, we knew that that was part of being in office. So saying that the explanation is that I wasn't notified, I'm not sure. We think that that's valid.
Well, so I don't think that it would be a defense against, say, like a first time. I don't think it'd be a defense against it. Like, I don't think it'd be a good pattern to develop here. I think that the issue here, though, is that we have $9,000. I mean, the statute says that the majority of these are well outside the statute of limitations, as far as I interpret. I would say that when you have a pattern and then it's not ever enforced for a long time and you don't get any notice, I do think that causes an issue. I would say it's the same thing as And I don't know, I've had to defend and prosecute speeding tickets before, and if you had a police officer who was tracking someone over and over and over again, and then tried to bring up all the tickets for every single speeding violation, even though they only got them on the last one, that's not really how the best way to go about it. And that's why I'd say it's an administrative error is that the statute does say that within 90 days of a violation, these are supposed to be brought up and addressed with the Commonwealth's attorney going, the local Commonwealth's attorney going and collecting the fine amount. That wasn't done for any, for that matter. So, again, I'm not saying that, again, Mr. Cross is not saying that, you know, this is the way things should be done. But we do think that because of the fact that this is an issue with the administration of the actual enforcement portion of it, the current fine, the fine as he received it is very much excessive. And I think that that's why what we're asking for is we're asking for the $500 fine for a first-time party offense within this.
Thank you, Mr. Chair. So I'm reading this code section. And it says a prosecution for any violation of the Campaign Finance Disclosure Act 24.2-945 at sequence shall commence within 1 year of the discovery of the offense, but in no case more than 3 years after the date of the commission of the offense. It seems to me that the discovery, of course, these are public filings, so the discovery should be the date which it was missed, right?
Yes, that's yes.
I'm not your honor. That makes my money. Let me ask you this. Is there anybody here from Rockingham County Registrar's Office to explain why there was this gap in time and enforcement?
Lisa Gooden.
Okay. So I guess that's my question, because
Okay,
I
let's
think
hear
the
from-
statute of limitations target is
I
pretty
think
obvious.
it's entirely appropriate to hear from registrar at this point.
Lisa, are you available?
Yes. Can you hear me? Can you hear me?
Yes, yes.
Okay. So Mr. Frost's campaign finance person noted that the change took effect April 16th of 2023, but no amendment was filed until 10/27/2025. So there was a lapse from when that change was noted in communication to elect. But no amendment was filed on behalf of the Cross campaign until 10/27/2025.
Okay, so follow-up question. So what's the significance of what you just told me? Were you not aware that he was a candidate?
No, that's not the case. It's just his campaign treasurer had noted that there was a change effective April 16th of 2023, but then nothing was filed pertaining to that amendment until just this fall, 10/27/2025.
One more follow-up question. So ma'am, the statute says that you have to bring an action to collect this fine within 1 year of the discovery of the offense. And some of these offenses date back to 2021 or early 2022. What prevented you all from knowing that there was an offense?
If I'm not mistaken, I think Ms. Alexander at the state had attempted to reach out to the Cross campaign, but no response was received by that campaign.
Thank you.
Yeah, I have a question.
Sorry, Chairman Davis.
I guess I have a question from her and then from the state, because what is your response? Are you the registrar, and have you been the registrar during this whole period of time?
Yes.
2027 to 2027, whatever it is, the period that we're talking about here. Have you have been the registrar?
Yes, I am.
So what has been your response to trying to collect their penalty? Do you have a record of you're trying to reach this campaign and they not responding?
I have some records, yes, here in front of me.
You actually submitted a request, or letting us know.
I would like to know real quick, as I have not seen any of that, whatever they've provided to state.
I need some questions from the street.
Yes.
Let's hear from elect.
Do you have a question, or-
What I'm hearing from the registrar is that that she's now saying that the state board of elections was handling something as though it was their responsibility. Now we're back at the state level, that the state board was responsible for requesting these penalties.
So any communications that we have with Mr. Cross was shared within board papers. So that's all the information that we had, and as well as anything referencing the penalty working with the general register was also reports as well. But the general registers are legally supposed to assess penalties.
So are you hearing me? That what I'm hearing is that you would have had the responsibility to ensure that this person complied by notifying him within a certain period of time, as I say, as Senator Stevenson is saying, has asked the question. He's showing that the record said was within 90 days or after you find out or whatever, within a year's period of time. We're talking from what you're saying is the 23rd to the 27th. Am I getting this right? It just seems like something's off here. But during this period of time that this person is being held accountable, you are assuming that the state had responsibility for doing this? The notification?
The state had sent some communication through email to Mr. Cross.
I want to know what you did at the local.
I followed through after I learned of the delay.
May I speak?
So, yeah, are you done?
I don't think you've answered my question. Just simply tell me, what is your responsibility, you directly related to receiving the outstanding penalty and notifying the candidates that they had an outstanding penalty? Collecting the money for the coffers, for the local coffers.
I mean, back in July, there was information that was sent to me outlining the time frame from February of 2021 through November 2025 about the status of Mr. Cross's campaign. So he was late in October of 2021. And that's kind of when the penalties began.
So, you're gonna plead ignorance.
I think we could spend a lot of time on this, but I think, assuming this is a statute, we have not through the court, it is. Violations 1 through 8 are, and I think that's really not, that's beyond dispute, I think. 9 through, excuse me, I guess 1 through 7 are timed out. Do I have that correct?
Yes.
Okay. Violations 8 through 10, I think the argument's slightly different, that you have a 90-day period in which to bring this to the attention of the candidate. By having the Commonwealth's attorney, for example, issue a summons, correct?
Basically, yeah, it's within 90 days of you Commonwealth's attorney, and I can also represent that did not happen.
And I understand that, and because of that, he never made the filings that he was.
Yes.
So I think 1 through 7, again, that's just, there's no legal. 8 through 10 is a little bit of a closer call, but I think it is true that because he didn't get notified, he really wasn't on notice that this was an ongoing requirement. And you can make an argument that he was because he's a candidate. I guess what I would certainly take 1 through 7 are waived at this point legally. 8 through 10, I think is a tougher call. 8 through 10, 11 is due.
Yes, Your Honor, and we're not contesting that. We really want to make sure that we're back on the right.
I don't there's any dispute that 11 is due. My recommendation would be is that we dismiss all these fines except the last one, which is number 11, which is a $1,000 fine.
But you-
Yes, ma'am.
So you had made comments and then made a motion.
I will make a motion.
Okay, you're not supposed to speak and then make until somebody else speaks.
I withdraw any motion. I just made a comment.
Vice Chairman Dance.
I have a sense of unreadiness, and I would like to have some input from guidance from state representatives as far as how this statutes and how we should look at this.
So, we can't speak as far as the statute of limitations is concerned. Just legally, we're supposed to assess the penalties. That's just how it's laid out for us. As for any other guidance, I mean, I can answer questions that you have regarding this petition, but I mean, ultimately, it's up to your discretion if you find that there's a cause.
So if we were to look at eliminating those suggestions from Senator Peterson, and we were to address the other, what would that equate to in penalties? What would that option be?
So if we're eliminating, you said what, the first 9 or the first?
1 through 7 is beyond the statute.
So we're down to
10, which is 3,000, and then the 25, was 715.
so the last 4,000 or the last 3,000? Sorry.
The last 4,000.
Okay, last 4,000. I mean, if that's what you would like to focus on, then that's within your discretion.
Mr. Chairman, I'd like to make a motion.
You want to refer to Senator Peterson?
No, that's all right. You do your thing.
Go right ahead, Delegate.
And you got me confused. Would like to grant relief for this to the tune of a fine of $1,000.
Second.
With that, is a motion properly seconded? I have one quick question.
Yes.
Is it factual that if this registrar could have any one of these years sent this to the Commonwealth's attorney?
Well, it would have needed to be assessed first before it would be sent to the Commonwealth's attorney. There's a period in which they have to either pay. Now there's a period in which they can appeal, but yeah, it's assessing the penalty first, then they can send it to the
So
Commonwealth's.
after much discussion, there is a properly seconded motion for a $1,000 penalty for this. Any discussion?
I'm in agreement, I haven't voted yet, but what I see is that there are some errors on both sides, or there should have been some more action on both sides of this. Now, those of us that have served and we've tried to do the best we could as far as reporting, we didn't want to get into penalties, so we stayed on top of it. So that's one side, but the other arm is there is a requirement, if you need to knock the hammer on me, you knock the hammer on me, so that there's two sides to this. So I'm agreeing with them.
Speak in favor of the motion.
I'm speaking in favor of the motion.
Thank you. Any further discussion? Call the roll.
Chairman O'Bannon.
Aye.
Vice Chair Dance. Aye. Dr. Stalling.
Aye.
Mr. Peterson.
Aye.
Secretary Alves.
Well, I think you're right.
There you go.
Okay, so that concludes that petition. Now we're moving on to Mr. Stephen Draper. So Stephen Draper, we had a board reporting deadlines that he missed. Total, the penalties amounted to $2,000. All of these report deadlines were from 2025. He is requesting full relief. His basis is that there was administrative error in the assessment of the penalty. The candidate alleges that the general register informed the candidate that there were no additional paperwork that was required. They stated that they were not informed of the exemption process and they have participated in multiple elections with no issues related to misfilings in the past. The general register and elect have both submitted documentation in the board's working papers. And I believe Mr. Draper is with us.
So do you want to address the documentation now or after? Let's have Mr. Draper. Draper, welcome.
Thank you.
No, I know that guy.
Go right ahead.
Mr. Chairman.
Go right ahead.
Yes, sir. Mr. Chairman, Ward Armstrong of the Martinsville Henry County Bar Association. Take this opportunity first to, Mr. Chairman, apologize for all the times I voted against your legislation. I was obviously.
You were very effective.
Misguided. In any event, Judge Meyer, Mr. Chairman, my client, Steve Draper, he's the sheriff of the city of Martinsville. He is the most senior sheriff, elected sheriff in the Commonwealth of Virginia. He's been on the job for over 30 years. As you can see from the filing, he thought that he was up for election this year, but was unopposed, did not intend to raise any money, did not intend to spend any money. And in checking with the local registrar when he was filing the necessary paperwork to get on the ballots, is there anything else I need to do? No, that's got it. And he thought that since he did not intend to raise or spend any money, that a campaign finance report was not necessary. When it came to his attention, I think in August, that no, that was not the case, that he had to file. He very quickly got everything filed within just a matter of days. And I would also point out that in his 8 elections and 30 years of service, he's never had a misfiling, a late filing ever before, and would not have done so here had he not mistakenly thought that he didn't need to file anything. And so we're asking under 24-2-953-6C that we think there's good cause here for full relief from the amount of the fines. The $2,600 would be a pretty substantial amount. He'd have to pay that personally. In some respects, it was one mistake amplified by the misfilings 4 times. Mr. Chairman, if I may, well, I'd like to expand on what Mr. Armstrong just said. As far as filing it, I did know the report probably had to be filed, but I thought it would be, if I didn't raise money, didn't spend any money, it would be at the end when I did my final reports. Always in the past, my other 7 elections, I had a treasurer that took care of all that, took care of all the finance stuff and all the reports for the board. And this is the first time I do it by myself. So I'm very fortunate I didn't have any opposition this past election. So that's why I'm just going to do it myself. I was not going to raise any money, and I didn't plan to spend money. But as it turned out, and I found out I needed to report them anyway, it was within 3 days. I got it on the 22nd. I got the notice on the 22nd from our registrar that I had violated and owed this. And within 3 days, all those reports were filed.
All right, thank you very much. Hear from the registrar. Introduce yourself.
I'm Sarah Workman. I'm the general registrar for Martinsville City.
Right ahead.
So yes, he was told several times verbally, there is no written, documentation. He was told verbally several times that he was missing his statement of organization. He stated that he told me several times that he had already completed this. I kept asking for a copy numerous times when he came by the office. There was no copy. At that point, then we had a lot of local contestants and we were busy doing petitions that it slipped my mind to keep up with him. So that was my error in that. But he kept reassuring me that he had already completed it. And that he was also informed that in March that this was required, that it had to be filed in order to be a candidate on the ballot. When we were assessing all the penalties, for Martinsville City, we realized that this was never filed. So then we reached out, and to my knowledge, that the statement of organization was also filed by one of his deputies as well. It wasn't still filed by.
Something you said that, and you explained to him that in order to get on the ballot, had to pay. So was he on the ballot?
No, in order to be on the ballot, he needed that statement of organization. But after talking with elect, that as long as we assess the penalty, because the statement of organization was one of the campaign finance, that we could assess a penalty for it. And not.
So you were allowed to go on the ballot without paying? Without him meeting the requirements that you're saying he should?
So yes, he should have had that in order to my assumption, be on the ballot. So like I said, that it was
on the ballot?
Yes, he was on the ballot, and he was unopposed.
So you're saying that you did all this
Verbally, there was nothing written. It was all stated that he had filed it, that there would be a copy. Kept asking for the copy, kept asking for the copy when he stopped by. And then again, like I said, my error in that, because I overslept to keep following up with him, because we had a lot of local contestants this year in our city. And when I did that, I overlooked that and then assessed it, and his was assessed in September 2nd.
Now, I'm not a lawyer, okay, let's clarify that. So, but I am one that has to be accountable, and I can say anything I want to say. But if I don't have anything to verify that this is what happened, then I don't understand. I don't think anybody would listen to me. I wouldn't be able to win any cases like that if I was a lawyer to say, take my word for it, that you're very good to me. And it's not that I don't believe in you, acknowledge that you should have followed up, but
There's no documentation.
there is no documentation to say that you did what you say you did. And I can say you did that, but if I'm looking at, just like if somebody's life's on the line and you said you did this, then can I accept that?
Absolutely.
Anybody else have any questions? Yeah, one quick question. Our documentation, our report here from the Department of Elections reports previous committee penalties in 19, 20, and 21. Are you aware of this? Do you know if the candidate paid those?
For 19, started in 2021, so I'm not aware of any 19 or 2021. If they were before June 1st of 2021, I'm not aware.
All right. Department of Elections, anything? Thank you for coming. Thank you all for participating very much.
Well, Mr. Chairman, we had a little bit of difficulty hearing the registrar from the audio. I think that there was, Mr. Chairman, you had a question as whether he had had any late filings. My client indicates he has never, to his knowledge, ever had any late filings.
I never remember paying a penalty at all.
So, I mean, if you want to know where the information came from, it's just public record. So those were the deadlines for the reports that he had filed previously. He filed a statement of organization back in, I believe it was
So
2019. And then those were the, 21, and then those were the,
So I'm respectful of the sheriff and Ward's comments. You all get these prior penalties or errors from public record?
So any reports that are processed through the system, and then it goes to CF Reports, which is a public domain site for with Elect. So you can look at all the reports online, and these were just the reports that he had filed previously.
So we really don't know whether these ever were filed.
Whether assessed.
Whether they were assessed or sent to the Commonwealth's attorney, and whether he ever, if we respect his comments, he was not knowledgeable, had no knowledge of any of that. And we're dealing with a new GR, with all respect.
Yes, again, like this was kind of goes back to the previous one. We had a question that's similar, and Elect would not have any knowledge of the assessment of the penalty. We just estimate it based off of, we know that this in fact happened.
So I'm gonna kind of cross-eyed this year.
That's fine.
But I have to say, going forward, we're gonna need, if we're gonna base decisions on this kind of information, we're gonna have to have better presentation. Anybody else, anybody have a question?
Mr. Chairman, I have a motion that we may provide partial relief and assess $500 for the initial statement of organization.
All right, that is there a second to that? Second. All right, there's a motion properly seconded. Discussion of our motion. Overall.
Chairman O'Bannon.
Aye.
Vice Chair Dance.
Aye.
Dr. Scully.
Aye.
Mr. Peterson.
Aye.
Secretary Elvis Long.
Thank you, Board. I think you earned your money today too.
Mr. Chairman, thank you. Good to see you all today. We all haven't changed a bit, have we?
All right.
You can plead the fifth. I will.
This is brand new stuff, and I apologize for trying to do the best we can to get to the bottom, do the right thing. All right.
Thank you.
The next one we have Jennifer petitioner candidate. There were 7 reports that were missed between July 2021 and July 2025. The total amount that is being requested in forgiveness is the full penalty amount of $5,200. They're stating that there were circumstances that made the required report requesting an extension of deadline impractical, and that there was administrative error in the assessment of the penalty. For the grounds provided, the candidate stated that they lost access to their email, was not receiving the notifications. The penalties may pose a financial burden on the petitioner is also what they stated. Elected to provide documentation in the board papers for this one.
Mr. Chair.
Senator?
Why would we not have the same statute of limitations issue that you have to bring this up?
That was not mentioned prior because we didn't account for that within these foregoing ones. It was just a.
We need to delve into that a little.
I can be counted for in the future, but you know, for these decisions prior.
All right, can we hear from, is the petitioner?
She is online.
Good afternoon, Chairman O'Bannon and Vice Chairman Dance and committee members. I truly appreciate the opportunity to speak with you today. I want to begin by saying that I do understand the importance of campaign compliance, and I regret and am embarrassed by the circumstances that brought me here today. This was never a matter of negligence or avoidance. It was my misunderstanding and the technical challenge that I had which I take full responsibility for. I did have some previous help on my campaigns from individuals who did have knowledge of this system and would assist me with this. And I made a mistake, but these mistakes are not the values that I want to represent. And I did not receive any correspondences about these late filings until September of 25. I was sent a certified letter by my registrar. I then went to her to chat with her, and she was very helpful with me in navigating through this process. So I do appreciate that. And I will say running a campaign alone was overwhelming for me. And in that pressure, I did stumble. I then went to seek help from a CPA who assisted me of this free of charge because of my relationship in the community that I have with people. They know that I really do want to do the right thing and work hard. I was 24 when I first began running, and I will say I was a little bit ignorant of all the requirements. And I will say that I would also be under that same statute of limitations for some of these. However, in the 12/31/24 and 6/30/24 and 6/30/25, I realized that on the campaign period of 10/28/22 to 12/1/22, that should have been my last report submitted. And because I made that error, that is why I then had the filings from 6/30/24 and then 12/31/24 and 6/30/25. And I would like to please ask the committees to please provide me with the assistance and please dismiss this for me. Thank you.
Thank you very much for being with us today.
Thank you. And I do sincerely apologize for this.
Welcome back.
There was no communication whatsoever. She was not informed of any of the filings before that until September 2nd of 2025. Again, that is on me. She has no idea until she received the letter that she had $5,200 worth in campaign finance. And that is because I did not realize that this was a part of my role. And that is 100% honest. Once I found that out, I went back to June 1st of 2021 and we assessed everybody until then. And so that is why she has $5,200 and she was never assessed before. So there was no communication, no nothing. This was following.
So, thank you very much. Hudson walked a long way to on this person.
I appreciate that.
I need to walk as much because the drive back is not what I'm looking forward to.
Sure, people open letters from you, they open them carefully now.
Probably.
Okay.
Everything's documented.
All right, any?
No, I'm just gonna say if the board's ready for a motion or has any questions.
Their motion.
Mr. Chairman, I move that we accept the petition their views.
There's a second. There's a second. Second. Okay, is there any further discussion? Call the roll.
Chairman O'Bannon.
Aye.
Vice Chair Dance.
Aye.
Dr. Shelley.
Aye.
Peterson.
Aye.
Chair Alvis.
This is kind of a teachable moment. It probably speaks to the issue why the bill came through the General Assembly. And I hope everybody will be. Yeah. Thank you, the registrar, for coming. Thank you. All right, next.
So I will state that the next one that we had planned was Mr. Lyons, but he was continued. So we're going to move next to Mr. Fred Lee Wright. So Mr. Fred Lee Wright, he has 9 reports that were filed between July 2023 and July 2025. Total amount of penalties was assessed at $70,200. He is seeking full forgiveness. He is claiming that there was administrative error in the penalty. He stated that in 2023, the candidate alleges that the general registrar at the time, Brian Clausen, informed him that she had filed paperwork. He assumed that there was no further action required. In 2025, later that year, he received the penalty notice and filed the report to close the committee the same day. The general register and WEC have also provided documentations in the papers for this one. And I believe Fred Wright is attending.
Yes.
I believe.
Come up, you've been very patient.
I never filed a report because I dropped out of it before. I never petitioned, went around and got the stuff to get on the committees. And I went to the registrar's office and told Diane that I won't run for office. I won't doing all this stuff, and I didn't ever open a banking account. I didn't do nothing. And I didn't know that I had to be doing the report till Amy called me. And then she taught me how to do it to my wife through the email to close it out. I don't know nothing about that stuff.
No good deed goes unpunished.
Right. And then I didn't receive nothing at all until after Amy called me. September the 19th, 2025. And then I received something on the 23rd. That was on a Monday. That's a certified letter from the register.
Was that the one that had the penalty? Still got that one? I'm teasing.
Hey.
All right, Mr. Chair.
You want to hear from the registrar? Thank you very much. Hear from the registrar?
Hello, Christy Creech here. I just want to say that I am the new registrar for King and Queen County. Just joined July the 1st of this year, 2025. And unfortunately, I've had no communication with Mr. Wright.
Like to have anything else you want to?
Yes, I just want to clarify something in the brief, because when I put in the brief, I did try to clarify an explanation, but in case you just looked at the top section and you kind of glossed over the explanation, the reason why it states that it's not submitted is because that first report, he was able to submit a final report for that and close it out. Legally, he's still like kind of responsible for those other reports, so that's why they were penalized. But otherwise, he did close it out. So if it says that
Closed out his campaign, but he never opened.
well, no, he closed it out at a later date. So if those show as not submitted, those were what the penalties were assessed for. But there's not going to be a for those reports. It's once you get through one final report, you can stop.
I just want to make a statement that,
Yes, ma'am.
that it seems that we are finding out that this is a valuable thing that we're doing. Because we're helping registrars learn, and what we're finding out is that it seems that the new registrars are just finding their way. They're learning as they go. And maybe this is a wonderful system across this Commonwealth as they learn the responsibility that they have to follow up. Not just leave people hanging. A lot of times, the first time the person's going for the first time, even those of us that did it over a period of time, we still had some things that might need to correct, some thing here or there, or some missteps. Can I make a motion to it?
Well, the floor is now open for a motion.
Mr. Chair.
Yes, ma'am.
I move that we accept.
Is there a second?
I'll second that.
All right. Discussion, full roll.
Chairman O'Bannon.
Aye.
Vice Chair Dance.
Aye.
Shelley.
Aye.
Mr. Peterson.
Aye.
Right, your patience has been rewarded.
Go on to the.
Mr. Chair.
Yes, sir.
I'm gonna make sort of an extempore comment, because I've been doing the legal research and talking with my colleague on the right here. I think we're seeing a lot of what I would call sort of dormant penalties that sort of rise from the earth, a la Frankenstein, when people come back and either reignite a campaign or had a campaign that was never properly closed. 24.2, let me make sure I got the site correct. It's 19.2-8 has the language in the code. And I don't know if this is new or not, but basically it says fairly specifically, a prosecution for any violation of the Campaign Finance Disclosure Act shall commence within 1 year of the discovery of the offense, but in no case more than 3 years after the date of the commission of the offense. Now, I will say we've had a kind of a dialogue as to whether or not prosecution is what we do or whether that's the Commonwealth's attorney. I would regard that 1 year as being binding on us also. I just simply I don't see any other language in the code, and my way of thinking, you tend to lean in favor of the defendant and against the state in these types of situations. So I just want to sort of put that out there. That's something that we need to get the word out there, that if you sit on these fines for years and years, you may be losing.
Thank you for your comments. I think this will be a learning curve for candidates as well as local registrars. We move forward. So we're all doing the same thing. We're trying to have good elections in this generation. I think this will make us a better place. But I hear your comments. All right.
Thank you. Thank you.
Okay, so we're gonna move on to, and I'm so sorry if I pronounce it incorrect. Tammy Bilski. So Tammy S. Bilski is the committee name, also is the petitioner. I think she did state that she's gonna be online with us.
I am, I'm here.
So there is 3 reports that were appealed. The 3 reports occurred from July 2024 through July 2025. Those reports weren't submitted. She stated that the circumstances made the required report requesting an extension by the deadline practical. And she's requesting forgiveness of her whole assessed penalties that amounted to $2,100. The stated grounds were that the candidate moved to Michigan in 2023, and they had no knowledge of the penalties. The General Register has provided additional documentation in court papers, and I believe that she's also here today.
Great.
Yes, I'm here as well.
So now, you want to hear from Ms. Bilski first? Let's do that, and then we can hear from the registrar. Ms. Bilski,
Hi, yes.
welcome.
Hi. Hey, Daisy, stop. Sorry. My Shih Tzu wants in on the conversation too. So Daisy, let's go outside. So I ran, I think it was 2023. The bank account was actually closed because of dormant, the 72 cents. Outside, Daisy. The 72 cents was taken by the bank for dormant fees and they closed it. I think I might have only had like $100 donation. But I'd never run for any kind of political office and probably never will again. So we moved up here and our daughter's boyfriend was actually stabbed to death in front of his 10-year-old, 6-year-old, and 5-year-old. Our daughter's boyfriend. And hers too. And that was, so we were actually up here before we bought a house up here. We were a good, well, let me see, April of 25, from November of 23 until April of 25, we were up here and could not get back because obviously with that, with our grandkids, that's pretty traumatic, you know? And anyway, just, I didn't know anything about it until September 16th, I think. I got the certified letter saying I owed $2,000, $2,100. Obviously, if I would have known that there was going to be a $2,100 fine or that I had anything to file, I would have done it. But this says I had 3 July 15th of 2024. I wasn't notified on that one. And January 1st of 2025, wasn't notified on that one. And July 15th of 2025, like I said, I got this I think it was the 16th of September. Don't quote me on that, but I think that was the first notice that I got that I owed $2,100. That's more than I spent on my entire campaign when I was running for supervisor.
Thank you very much for your comments. We appreciate your participation.
Thank you. I'm sorry about the pets. they've been still for a while, so
Dickinson General Registrar.
Yes, I'm here. My name is Kayla Deal, and I'm the Registrar of Dickinson County. The only thing that I would like to add to that is I do have communications from January of 2024 with Ms. Bilski, where we stated that the campaign finance report that was filed in December of 2023 did in fact still show that 70-some cents balance, and she was unaware of what that balance could have been. And she had left it off with me that she was going to call the bank the next day to find out exactly what was the issue, as to why we were showing a balance on the campaign finance, but she was unaware of one, and she would get back to us. At that time, she stated she had not been back to Virginia because of everything going on with her grandchildren. I had no communication with her after that because, as she said, she did move to Michigan, and it was not until I finally got an NCOA mailer returned to me with a Michigan address that I even had a way outside of email to communicate with her. She did state with me in September that she does still have access to that email that was assigned to Comet. We have previously been told on numerous occasions that when it comes to the campaign finance deadlines, it is not our responsibility to hound these candidates or prior candidates, that it is their responsibility to handle those filings themselves. And then it is the GR's responsibility at which time, if they do not file, that they need to be penalized.
Thank you very much. I appreciate you.
You're welcome.
Being on today and addressing this.
Mr. Chair, if I could just point out one thing here. The only limitation that you all have in granting relief under the statute is that the relief cannot include an exemption from filing a report. So everything does have to be filed. So that's just one thing I would point out here is, and I'm not saying what you're going to do, but if you were going to grant relief here, the reports still are not submitted.
Can I ask a question, Council?
Yes, sir.
Are you familiar with the excessive fines clause of the Eighth Amendment?
No, sir, I'm not.
The Eighth Amendment of the United States Constitution makes it unconstitutional to have excessive fines. So we would be levying a fine of $2,100 over 72 cents in the bank account.
Mr. Chair, I think it's totally in your discretion what you think is good cause or a good cause to grant relief. All I'm saying is that if you grant relief without these reports being submitted, it could be argued that under this code, you're exempting the person from submitting the reports that they still have to submit under law. So you may consider, granting
So let me, I'm sorry, I don't mean to, go ahead and finish up this.
just maybe granting like a continuance in order to allow her to file the report she's supposed to file before if you are inclined to grant relief in this case, because those reports do have to be submitted by law.
So let me ask a question. And every one of these other 15 people submitted these?
Yeah, as we noted that the data submission on all the other ones, they are late, yeah. So that's the only limitation you have in granting relief, is you can't just say, just forget about the report, right? You're fine. You can't do that.
And I will add to that I also put in the communication that I've had with Ms. Bilski, as well as the telephone conversations that I've had. I have reminded her that those reports have to be filed. I had also been in contact with Tammy Alexander at the state board to find out if Ms. Bilski cannot get back into her Comet account, how we can proceed. Because at one point she told me she had stopped the emails that were coming from Comet. So I'm not sure if that was a blocked
well, no,
thing
I
or
didn't.
what.
I didn't stop it. I don't know how to do all of that. But the bank account was closed January 31st of 24 due to dormant, and I submitted that.
Thank you, Ms.
So,
Bilski. So I'm going to take a chairman's prerogative here. It's my understanding that we have a fair amount of latitude in how we deal with these things.
Correct, you get to decide.
So if we were to forgive the penalty contingent on filing the paperwork, that be something that would be defensible and appropriate statute.
Just from a procedural standpoint, council obviously can opine on the legality of anything. I would just say this might be an appropriate situation to continue these proceedings and take them up after the person files the required report, just because, again, if you take away the penalty, then that could be viewed as excusing filing the report, essentially.
So a way to get there would be to continue this and ask Ms. Bilski to file her last report from Michigan, and then we'll give her 73 cents at the next meeting.
That's what you are possibly saying.
Ms. Bilski, can you live with that? We can't hear you, ma'am.
I'm sorry, I was muted. So continuing it and then file the reports, I gotta figure out how to get into that system. And then just like the third report, just make it the final one. How do I do that with the closed bank? Yeah.
It's a paperwork issue with these people for the legality of it. So can we do it for?
Alex can assist her. She can
assist her.
contact, yeah, she can contact us. I have her email address, I can reach out to her after this meeting and assist her.
All right. Yeah, it's TammyBilski@gmail.com.
All right, is there a motion?
Question to continue.
Is there a second?
Second.
All in favor? Call the roll.
Chairman O'Bannon.
Aye.
Vice Chair Dance.
Aye.
Dr. Stelling.
Aye.
Mr. Peterson.
Okay.
Could just step back for a second to the previous one that we just did, the right, who had a bunch of not submitted as well.
Oh,
This-
I thought I clarified it as well, to close out that committee with that first report penalty. So when you file a final report, it closes your committee, so it stops the obligation to file going forward. It's just that those reports that were happening in the meantime until you file that final report is still your responsibility.
So all these not submitted on here, he still has to file or not?
No, the first report was a final report, and so if you look in the timeline, that report came before the others. So when he closed that one out, he has no activity left to report after, because he closed it as a final report.
Okay, Friends of Christopher Adams.
Mr. Chair, I'm here.
So,
Hang tight.
Right, so, Friends of Christopher Adams, we have the petitioner, Christopher Adams. He is appealing for a penalty that was filed back on January 15th, 2025. He filed the day after. He is filing in the basis that circumstances made filing required or requesting an extension by the deadline was practical. He was issued a $1,000 penalty. He's requesting full relief. He's stating that due to oversight, the candidate missed the deadline. The candidate experienced issues trying to file the final report. Alexis provided documentation in the board papers as well. We should start contacting the candidate. That is all I have in my brief. We want to Mr. Adams.
Mr. Chair, I think you cut out. Are you asking for me to speak, sir?
Yes, sir, but we're gonna need to be able to see you for this to count. That's the FOIA law. So if you can show it, there you go. Thank you, sir.
Yes, sir. Sorry, I was picking up a daughter from school. So the issue is mine. Some of this is my responsibility or my lack of tech savviness dealing with comment. Like some of the other candidates, obviously I ran unopposed to my account with dollars that I deposited into my account just to open it for election purposes. Never received a dollar from donations, never spent a dollar on the campaign because I ran unopposed. And because of that lack of activity, I lost contact of it. And then toward the end, I was trying to close the account numerous times because I had already closed the account at the bank literally a week after the election because there was no other activity to take place. So I removed the $100 that I deposited, and the bank account at Truist was closed for the campaign committee. And still continued to file and made numerous attempts to try to file the final report. But in comment, it was not cooperating with me, and I had made numerous attempts to reach out for some assistance. And finally, was able to reach out to Emily, and she provided some feedback, I think via email, if I remember correctly, with the proper guidance. And I had the account closed within an hour, I think, of when I received that, once I had the proper instruction. I didn't have a campaign finance committee because it was just me. I ran unopposed. So that's really the only rationale I have for the late filing. That's it, unless somebody has any other questions.
All right, so thank you very much. Hang tight. We have the registrar from Amherst.
Yes, I believe she is on, what's the name?
Ms. Robinson was on at one moment. I saw her on.
Yeah, pizza. She is on, and your mic's unmuted. Keeper, can you hear us?
Are you able?
We actually had it.
She can hear you.
All right,
Can you hear me?
Yes. Go right ahead. Hear your perspective on this penalty.
My perspective on the penalty is I should have sent him a letter prior to July of this year because the penalty was for the second half of 2024 and it was an oversight on my part. But he did file the day, I believe it was the day after the due date. And since then has made the corrections to his account and has filed the final report. And he did visit our office earlier this year with some questions on how to do that. And I was unable to assist him with the comment. I did give him the connections to Department of Elections to get more information on how to navigate through COMET and be able to file that final report and close out his account.
Thank you so much. We appreciate your comments.
Thank you.
Well, I mean, elect did reach out to the candidate back in 2024, January 2024, by Tammy Alexander, and she did give instructions on how to close out. I'm the one who assisted him, and I basically just followed the exact same instructions. The problem was just the same.
All right. Any members have any questions? A motion?
Mr. Chairman, I move to grant the appeal petition.
Discussion, call roll.
Chairman O'Bannon.
Aye.
Vice Chair Dance. Aye. Dr. Stelly.
Aye.
Mr. Peterson.
Aye.
Secretary Ellis.
All right, and the good news is,
This is the
this
last
is the
one.
last one.
Yeah. So, we have last, we have Beverly J. Jones for CCSD, petitioner Beverly J. Jones. She had a penalty that was appealed for the July 15th, 2025 filing. She's appealing the $100 assessed penalty. For date basis of appeal, she stated that there were circumstances that made file required or request an extension, but the deadline practical. The candidate stated that she had difficulty understanding the campaign finance compliance expectations, and they experienced issues with their email server, and they have since made corrections. Again, General Register and elect both submitted documentation within the board's papers. And I believe Beverly Jones is here.
Okay, hear from the appellant.
Ms. Jones, can you hear us?
Yes, I can. Can you hear me as well?
Yes,
Yes.
go right ahead.
Good. My name is Bev Jones. I was a candidate for Campbell County School Board this past election cycle. I'm going to be as short as I can because I've got 5:15 tickets to go and see Nuremberg. We missed our first filing, basically a rookie mistake. We were overwhelmed by the number of details involved with running for a public position. We were asked to consider running at the end of June. So the pace was just incredibly fast for me personally until we got our qualifications, signatures in, and then did all the reading, the multiple facets of running for public office, elected office, just, it was too much. So I do want to add that Kelly Martin, who's our county registrar out here, she was just a wonderful help and support. She did send me notifications on email that I needed to hustle and get the filings in on Comet, but wouldn't you know, we live out in a rural area in Campbell County, and that was coincident with some problems we were having with our internet delivery. There were delays that happened, so, comedy of errors. So I'm requesting that the board have mercy on me as a first-time candidate and forgive that fine.
All right, thank you very much. We have Campbell County Registrar.
Yes. Ms. Martin, can you hear us? If you can please unmute yourself.
Yes, I'm here. Everything that Bev said is correct. She was
Ms. Martin,
late.
Ms. Martin, we need to be able to see you for this to count. That's the FOIA law. So if you can turn on your video, I would appreciate it.
All right, can you see me now?
So we can get the feedback.
We've got one.
All right, I'm not sure why you can't see me now because I can see it on my end.
At the bottom of your screen where it says stop video or start video.
There you go.
There we go. Yeah, everything that Ms. Jones said is correct. I had talked to her several times. She knew and was aware that she needed to file, and once she did get the hang of all of it, that was the one and only time that she was late on her filing.
All right, thank you.
I don't really have anything else to add to this. If the board has any questions or want to do a motion, then have suggestions.
Anybody have any questions of any of these?
No, Mr. Chair, I move that we accept the report.
Is there a second?
Second.
Discussion, call roll.
Chairman O'Bannon.
Aye.
Vice Chair Dance.
Aye.
Dr. Stelling.
Aye.
Mr. Peterson.
Aye.
Secretary Elvis Long.
Thank you very much. So this was a learning experience. More to come. I appreciate everybody. I particularly appreciate the effort and consistency. We're hopefully going to get to a place where we can do this in a good fashion. Anyway, that completes our regular agenda other than a closed session. Is there a motion?
Mr. Chair, pursuant to Virginia Code Section 2.3-371A7, prove that the board go into closed session for the purpose of discussing pending threatened litigation in accordance with Section 2.2-371(2)F. Susan Beals, Commissioner of Elections, and Murphy, in his folio Office of Attorney General, and will attend the closed session because his presence will reasonably aid the board in its consideration of the subject of the meeting.
Would the make that motion, accept the friendly amendment to include discussion of the campaign finance penalty appeal process.
So move, Mr. Chair, I had that tonight.
Mr. Chair, can you
Yeah.
please add Mr. Shasta?
And we would add that Mr. Costa can stay with us for that.
And we'll add Mr. Costa.
All right, that's the motion. Call roll.
You need a second.
Second.
Thank you.
Chairman Bannon.
Aye.
Vice Chair Dance.
Aye.
Dr. Stolly.
Aye. Thanks for keeping me honest. Okay, thank you all very much.
Yeah.
It wasn't a lot of
Thank
fun, but it was a good learning experience.
The meeting and open session and take roll call vote certifying that to the best of each member's knowledge, only such public business matters lawfully exempted from open meeting requirements under this chapter, and only such public business matters as were identified in the motion by which the closed meeting was convened or heard or discussed by the State Board of Elections. For a second?
Second.
Call roll.
Chairman Bannon.
Aye.
Vice Chair Dance. Aye. Dr. Stolly.
Aye.
Mr. Peterson.
Aye.
Secretary Elvis Long.
No further business. We will see you all on December 1st at 1 p.m. Where? Where's that meeting?
The General Assembly Building.
Up here.
Catch him,
What's
catch
the need
him.
to
He
sign?
gotta come back.
Ciao.
Ciao.
Come on, catch him, please catch him.